Turning to page 26 of the calendar. Page 26, House Bill 962, a bill to amend and reenact a section of the Code of Virginia relating to carrying concealed handgun, secured container or compartment in vehicle. Report from the Committee on Militia, Police, and Public Safety.
Gentleman from Rockbridge, Mr. Klein.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, House Bill 962 would codify existing case law that clarifies that when a person can carry a weapon in a vehicle, it must be in a container that is secured but not necessarily locked. That was decided in a case in 2010 and this would, or 2012, and would put this case into the code. I'd hope it would be the pleasure of the House to engross the bill and pass it on to its third reading.
Gentleman from Henrico, Mr. Morrissey.
Thank you, Mr. Speaker. I rise to speak to the bill.
Gentleman has the floor.
Mr. Speaker, ladies and gentlemen of the House, I would hope that my colleagues on the other side of the aisle don't vote for this bill merely because it's perceived as pro-gun, and I hope that my colleagues on this side of the aisle don't vote against it because it's perceived as pro-gun. Rather, I hope you would vote against this bill because of the compelling state reason to keep handguns out of the concealed weapons out of the hands of people that are up to mischief. And also, I would ask you to vote against it because it completely guts the concealed bill legislation. The concealed permit or concealed gun legislation is contained in lines 13 through 22, essentially sets out what this bill does. It's been codified for at least 63 years, and it says if any person carries about his person, that means on his person or somewhere where he or she can reach, hidden from common observation, any pistol or weapon of that kind is guilty of a Class 1 misdemeanor. That makes sense. There's also exceptions to it, and those exceptions make sense. One of the exceptions is that a person can carry a concealed weapon if he's in his place of business. No problem with that. Again, you're in your own bailiwick. Why not be able to carry a concealed weapon in your own shop? Second exception says that if you're going to and from a shooting range, you're transporting that gun. If that gun is unloaded and is securely wrapped, that's an exception. Another exception says if you're a member of a weapons collecting organization and you're going to and from that organization, as long as it's unloaded and secured, that's an exception. Fifth one says if you're going from your place of abode to another place to get the gun repaired, you can carry that concealed weapon as long as it's unloaded and secured. But this legislation, Amendment 10, completely changes that. You now can carry that gun loaded. It doesn't have to be secured. Let's be clear why we have this legislation. Every day in the Commonwealth, people carry guns who are up to mischief, it's concealed, and police stop them. Consider the following. It's 12 midnight, there's a Fast Mart in Colonial Heights, and the teller sees 3 people outside in a car that appear to be casing that Fast Mart. They call the police. The police drive up, and heretofore, everybody else in that car took their gun, stuck it under their seat. The police, acting in response to reasonable articulable suspicion, looked at that car, looked inside, found those guns underneath the seat, and charged the person with possession of a concealed weapon. Now what do we do with this legislation? That same police officer arrives, the mischief makers who have been casing the place now take the gun that's loaded and put it in the console that's not locked. Put it in the glove box that's not locked. Those people are no longer violating the law, and the police officers can do nothing about it. That doesn't seem to make much sense to me. I know there are former prosecutors on the other side, Delegates Lupasi and Bell and Gilbert, who have prosecuted hundreds, if not thousands, of cases where somebody had a concealed weapon underneath the seat and they were charged and convicted. But now we all know what's going to happen. The police officer pulls over that person in the car, and the gun, which has been concealed, now goes into the glove box or the console, and the police officer is in danger. It guts this legislation. Similarly, if you look at the amendment, it allows for somebody who is in a vessel, a boat, to have a loaded weapon as long as it's in a compartment. So now we are going to allow somebody who is in a boat where alcohol is lawful, legally allowed to be consumed, to be operating a vessel, have a loaded gun, be consuming alcohol, and it's not a violation of the law. I would imagine that right now the state police, the Sheriff's Association, and the Commonwealth Attorneys Association would be wildly opposed to this legislation. I'm not asking you to vote for the bill or against the bill because of your pro-gun stance, but vote against this bill because it's bad law. It negates at least 6 decades of existing legislation. It puts our police officers at risk, and it's bad for the Commonwealth. Thank you very much.
Gentleman from Rockbridge, Mr. Klein.
Thank you, Mr. Speaker. Speaking of the bill.
Gentleman has the floor.
Mr. Speaker, I'd first thank the gentleman from Richmond for reminding me that in committee when this bill was considered, the Commonwealth's attorneys did speak, and they spoke in favor of the bill. They spoke in favor of the bill because it provides clarity to a law that was adopted in 2010 when the gentleman was here, and I want to thank him for reminding me of that debate, because this bill does not repeal that section or add that section to the code. This debate is not about whether or not this section should exist. If the gentleman wants to remove the section of the code dealing with secured containers, he can get his own bill. But this bill simply clarifies that when we say a gun must be secured in a container, that secured does not mean locked. And I take you back to 2010 when many of my colleagues were here. The original legislation did say locked when it was passed. And the governor at the time sent down an amendment to change the word locked to secured. And this body voted to accept that amendment. Many of you voted to accept that amendment. I doubt the gentleman from Richmond voted to accept that amendment. But the intent of this body was clear. We meant it to be secured but not locked. That was what the Court of Appeals decided in 2012. They read through the debate on the floor. They saw the governor's amendment. They saw how this body voted to accept it. They saw how the Senate voted to accept it. And they saw that the General Assembly meant for it to be secured but not locked. We're not debating whether or not you can carry a gun in a car. Existing law already allows you to do that. We're just clarifying that you can carry it in a container that is secured but not necessarily locked. I hope to be the pleasure of the House to engross the bill and pass it on to its third reading.
Gentleman from Portsmouth, Mr. Joanno.
Speaking to the bill.
Gentleman has the floor.
Years ago, when I was practicing criminal law, I went to the city of Chesapeake, and I was just sitting in the background waiting for my case to be called, and another attorney from Portsmouth had a matter before Judge Hodges. Judge Hodges had served in the legislature some years prior, and the issue that came up was a person was arrested as a result of having a firearm in a glove compartment. And at that time, Judge Hodges says, well, you know, there's an unpublished opinion that says you can carry a firearm in your glove compartment. I don't know why it was unpublished. All I can say to you is that that case was dismissed on that basis. He had a copy of the case. Now, this goes back to 1989, I believe it was. And so I don't know whether the law has changed since then. Don't practice any criminal law. But there was an unpublished opinion which said you could carry a firearm in your glove compartment. And so I think all this bill does is says secured, doesn't have to be locked. And so I just offer that piece of evidence that I know back in '89, and I have not researched the case law to see if it's changed or not.
Shall the bill be engrossed and passed to its third reading? As many as favor that motion will say aye. Aye. Those opposed, no. No. Bill is engrossed and passed to its third reading.